Hearing in the appeal, guest and another against guest.
Well, we had similar difficulties when Whitehall was blocked recently. This morning we were having to run down with all our files and boxes.
I will drive perfectly happily on my single one for the time being, anyway. So
Good to hear.
Please continue.
Thank you, my lords and ladies. I appear for the appellants in this matter before you, appellants David and Josephine Guest, and I'm with my learned junior William Moffat, and we're instructed by Thrings. Penelope Reid, Queen's Counsel, appears for the respondent to the appeal, Andrew Guest, with her junior Philip Jenkins, and they're instructed by Clerk Wilmot. As a very, very brief overview, can I say that we submit that there is, running throughout the proprietary estoppel jurisdiction and cases, a golden thread. And that golden thread is that the relief in proprietary estoppel must be the minimum equity to do justice to the claimant, or as reformulated by Lord Justice Walker, to do justice between the parties, the minimum equity to do justice. We see that found in what is the foundation of the modern line of authorities, which is Crabb and Arron. Lord Justice Scarman uses those very words. We see it in, as it were, the twin columns of Gillette and Holt, and Jennings and Rice, both in the Court of Appeal. We see it more recently in Suggett in the Court of Appeal, where at page 1186 of the bundle and paragraph 42 of the judgment, Milady Arden said that there is no issue about the minimum justice. Sorry, let me just find that. Yes, there is no issue about the court having to do the minimum necessary to do justice to the claimant. And again, in more recently and more, 2019, we see it at paragraph 95H of the judgment, which is on 1126 in the bundle. The judge's focus should have been on the minimum provision that was needed to satisfy Stephen's equity. So that, we say, is the critical golden thread that runs through this jurisdiction. And when we come to what has been described by Lord Justice Lewison as the lively controversy, which we see in Davies and Davis, which is page 932 of our bundles, he describes in paragraph 39 that there is a lively controversy about the essential aim of the exercise of this broad judgmental discretion. One line of authority takes the view that the essential aim of discretion is to give effect to the claimant's expectation, unless it would be disproportionate to do so. The other takes the view that the essential aim of the discretion is to ensure that the claimant's reliance interest is protected so that she is compensated for such detriment as she has suffered. So expectation interest or reliance interest. And we know he then goes on to say my scholarly opinion favours the second approach, and he refers to Snell's equity, and Wilkin and Garley and waiver, variation of estoppel, and so on. And later on down that paragraph, he says, logically, there must be so for the second approach, since the essence of proprietary estoppel is the combination of expectation and detriment. If either is absent, the claim must fail. If therefore the detriment can be fairly quantified and the claimant receives full compensation for that detriment, that compensation ought in principle to remove the foundation of the claim. But what we say about this, of course, is that if one compares the two, sides of the lively controversy, giving effect to expectation, as opposed to...
How do you compensate for the non-financial aspects of detriment?
How do you do that? I'll certainly come to that in my submissions. In my submission, what one has to focus on is actually the financial aspect. The non-financial aspects are, we say, often a chimera. They're often illusory. They're often impossible to grapple with. And when you come to the cases, my lord, what happens is there is often a clear financial side to it, which is very usually the diminution in earning capacity, the loss of earning capacity over the period. And then it is said that one adds to that, for some reason, the 3 decades over which that financial loss was calculated, and that then becomes some kind of non-financial detriment, the mere span of time. In our submission, that's an inappropriate way to approach it. The whole point about trying to calculate the financial loss is you look at those decades and see what was the loss. To say that because they've devoted their whole life, or they've devoted 3 decades, or whatever it is, to that work, there is an extra non-financial detriment, we say is a misconception. And what we say is that when you look at these 2 rival ways of dealing with it in the controversy, it's self-evident that the giving effect to C's expectation is itself the maximum equity.
How can that be if the proprietary estoppel can arise by virtue of non-financial detriment? It comes into play in deciding whether there is a proprietary estoppel, but it's left out of account when one compensates for the unconscionable conduct.
The courts have always recognized that there can be non-financial detriment. And there will be circumstances where the detriment may be of a kind which has no financial aspect to it. If the claimant has put up with a lifetime's bullying, a lifetime's maltreatment, has worked as sometimes they do, in terms of almost servitude, then that is something to be considered alongside the financial aspect of that. I accept that. One non-financial aspect is, but if one looks at the cases, I mean, I'm sorry to take you back to that, but the specifics help. If we look at Gillette and Holt, for instance, the financial aspect, there was no financial loss in terms of the income earning capacity of the claimant in Gillette and Holt. As Justice Carnworth found as a fact, and it was not challenged on appeal, that his recompense had been a perfectly fair recompense for the work he did throughout that period. There were extra things added to it, which were focused on in the Court of Appeal as a reason to overturn Ms. Justice Carnworth's decision. One of them was that he'd got off the housing market by selling a house because he was confident that he would get a house from his employer. It had been promised to him. That obviously is financially ascertainable. One would just look at the property, see what it was worth, see what he sold it for, see what it was. That is eminently financially ascertainable. Another one was the pension. He said that he had not provided for his pension. Again, that would be financially ascertainable very easily. Then it was said, well, he worked devotedly, loyally for his employer over his 3 decades. Well, it is not a detriment to work to the best of one's abilities. It's not a detriment to do a good job. We say that was a misconception. He had to subordinate himself in one sense because he had a quasi-familial relationship with his patron in that case. But that was, in a sense, a two-way street. The only significant point raised there was that Mr. Holt had suggested that his son should go to Gresham's school, his eldest son, and had paid for that, but that Mr. Gillette then had to pay for the education of his second son when Mr. Holt wasn't prepared to pay for that. That's a sort of balancing exercise, but in that case, there was no, we say, financial loss or burden or detriment suffered by the claimant in Gillette when one looked at the figures he'd earned. It was just the Commonwealth dealt with that. And the extra non-financial, we say, were, in that case, illusory. They were a chimera. Gillette and Holt is important because it establishes the legal framework exactly. It says that you must do the minimum to do justice. You must. The whole of the claim is the maximum equity, the maximum claim, and in that case, the maximum claim was to some 876 acres, and 100 acres were awarded. So that it was the minimum was obviously an awful lot less than the maximum in that case. But there is no explanation in reality of how they got even to that figure. When one looks to see in judgments in these sort of cases how the court approaches this concept of evaluating the remedy for non-financial loss, the remedy itself has to be financial. How does it do it? And so often in the cases, there is absolutely no indication of how you get to the figure that is the final award in the remedy.
The remedy has to be financial in the sense that it involves the payment of money or the conferral of some proprietary right, which can be valued.
Yes.
But the remedy isn't inherently financial in the sense that it's always damages or even equitable compensation.
Yeah, my Lord, I accept that distinction. It is financial, though. It is financial proprietary. Property has a value.
Yes, and I accept it's something that it is bound to be capable of being valued.
Yeah, everything has a value, but you could get a right to live in a home for the rest of your life. That's
then you could
charge.
Those cases are, in a sense, more difficult. It is a difficult area, and there were a number of those sort of cases when the jurisdiction was just being developed, and the farming cases, in our submission, form their own area of law, which, while must be applicable throughout, can be looked at rather more closely. It was also, Lord Briggs, you said that they have to be financial, they have to be property based. If one thinks about Gillette and Holt, he was awarded 100 acres and the house that they lived in, and £100,000 too. He had to give back some shares, which may have been equivalent to £100,000. It's not entirely easy to see. As I say, there's no explanation for that. If one had to infer and guess, one might say, well, he'd been promised a farm. The farm he'd been promised was obviously far, far too large, disproportionately large. So we'll give him a farm that's appropriate, a farm on which he can farm of 100 acres, possibly. But in our submission, when one's trying to look at these cases, one has to work out how it is that, having assessed what the financial loss is, one then jumps to a significantly higher figure when the awards are made. How is it that that's done? And so often there is no explanation. If we look, for instance, at judgment in this particular case.
Would you just give me a moment, Mr.
Yes, of
Simon?
course,
It's
of course.
easier to do it, I suspect, without us having to rise, but it's probably too much of an interruption for me to concentrate on what you're saying.
No judge needs much distraction to lose his concentration on what I'm saying.
You do yourself an injustice, Mr. Jones.
I have no screen. On-off light is flashing on the... Yes, I know it did. It's on. Well, we'll just have to do without it. We'll have to continue, Mr. Timon, with no second screen. Could I be supplied with a set of papers? Thank you. Do continue.
Yes, I think ours are all marked up, unfortunately. Otherwise, I would have just handed ours up.
No, I can.
I can probably manage on one, but there we are. Thank you.
Get you another screen.
No, don't bother. We'll wait too much.
I was just about to take you to see how the judge dealt with assessment in this case. And he deals with it, we see it on page 288 of the bundle, which is in the printed version, of course. And paragraph 282, he comes to remedy My findings above mean that it's necessary to exercise the broad judgmental discretion in endeavour to do what is necessary to avoid an unconscionable result, or alternatively to identify the minimum equity to do justice. So he sets out the appropriate considerations there, legal considerations. Perhaps unsurprisingly, I found this to be the most difficult aspect of the case to decide when the outcome rests upon that discretion and not just findings of primary fact. 283, he says, I do not regard Andrew's equity as being built upon an assurance of a quasi-contractual character, important because of the dichotomy and distinction built in by Lord Justice Walker, of course. The promised extent of Andrew's inheritance of Tump Farm was too uncertain for that, and his own recognition of his siblings' expectations upon the parents' estate confirms as much. Although it follows from my findings that Andrew would have been prepared to continue his life on the farm had he known of the terms of the 1981 wills, the fact is that he did not know them, and he cannot be said to have struck any kind of bargain with his parents along those terms. My judgment is the first point to bear in mind when considering the ultimate Mr. Jenkins' submission on the extent of his client's equity. Mr. Jenkins, in paragraph 17, he had said that the claim was what the judge eventually ordered, 40% of the land, 50% of the business. So that's a first point which one might be thought to be reducing the actual claim. The next point arises is the submission the relevant assurance was as to an inheritance after the second death of his parents, and David and Josephine may expect to live for many more years yet in their home. Even though Andrew expected to take on the farming business at Tump Farm after his father's retirement, and thought he effectively had in 2012, he did not expect to acquire any interest in the land and buildings before his father's death. So that's another matter which might be expected to reduce because it's the acceleration point. 285, I must determine the extent of his equity now during the parent's lifetime. But the fact that the exercise involves acceleration does not mean that this incurred aspect of his exploitation is immaterial. And then there's reference to the solar panels and so on. And then there's a fallout, so he says there should be a clean break. I shall have to come back to that. Then 287 seems almost inevitable the mitigation of tax will not be achieved, so that's, one might think, is another reason to be reducing. But he then says at 288, in my judgment, the appropriate remedy to satisfy Andrew's equity is a lump sum payment to him, which affects the following components. And then it's 50% of the value of the farming business, 40% of the value of the farm itself. And that is the claim that was made. So we see here a strange process where if one looks at the way Lord Justice Walker phrases it, one can identify what the maximum of the claim is, consistent with the assurances given and so on. But then, to find the remedy, one looks to see what the minimum equity is that does justice. All that's happened here is he's taken the maximum, he said a few things which one would then expect to reduce it, and then he's given the maximum. And we say that that is, first of all, not an explanation of why he's done that. There's no explanation of why he's gone for those figures. And it's contrary to the earlier paragraphs which suggest that there's going to be a reduction in the maximum, and also fails to reflect what he himself has given as the basis for his decision on the judgmental discretion. Because a broad judgmental discretion can't be just exist in some ether. It can't allow the judge to sit under his portable palm tree, a phrase often used in these cases, and decide what he thinks would be fair or right. It must be dealt with within a principled framework, and that is avoiding an unconscionable result or identifying the minimum equity to do justice. And we don't see that here.
But just saying that avoid an unconscionable result and do the minimum equity to do justice, I mean, that may be a start, but it hardly gets you anywhere. But the first thing you surely have to decide is what is the equity that you're seeking to remedy, and then you have to decide how do you go about remedying it. And either it's the promise or it's a detriment, you have to decide which it is, don't you?
That was the submission in the Court of Appeal in this case on behalf of the appellants, that one must identify the equity. The equity itself is the claim which arises out of the assurance and the detriment.
Yes.
It is a claim, and at that stage, when it's formulated as an equity, it's an inchoate, and it's an uncompleted concept. It's the feeling that, it's the submission, it's the recognition that through your detriment, you are in a position which is unconscionable. And therefore, once that inchoate conclusion has been formed from the assurance, reliance, and detriment, one then looks to see how that's going to be, then what remedy is going to be given to that. So one doesn't actually, the Court of Appeal rejected the idea that you have to focus on ascertaining exactly what the equity is.
Well, they rejected it, but you're here, presumably, because
yes,
there's some need for some guidance from this court. And I don't think we're going to take the law much further if we just say you've got an assurance on the one hand and a detriment on the other, and we sort of do this and we come up with a number. I mean, that's just a recipe for more of these cases coming through the courts. And nobody will know before the case starts how they're going to resolve it, because it ends up just being the length of the judge's foot.
My Lord, absolutely. Absolutely, my Lord. And I entirely accept, and that is the basis of our argument, that you should look at detrimental loss.
Well, we're looking, if that's your submission, then I'm hoping you're going to develop it and give us a coherent statement of principle that we can adopt.
Well, I've already shown you Lord Justice Lewison in Davis and Davis.
Yes.
Where he says that if one takes unconscionability as the basis for the proprietary estoppel jurisdiction, then if one can remove the unconscionability, then the court is giving satisfactory relief.
But these are just different formulations of the same thought, aren't they? I don't see how that takes you any further. I mean, the difficulty is that when you're looking at establishing the estoppel, you have to show both an expectation and at least some detrimental reliance and unconscionability. But there's a difference between what you have to show in order to establish there has been some detriment in order to satisfy that element of the cause of action, and then going further and saying, well, not only did we suffer some detriment, look at what it was, but if you then want to go on to value the remedy based on actual detriment, you have to go a lot further in quantifying the detriment, which may not be what you need to do just to establish the existence of the estoppel. And I think it's that, and particularly how one deals with non-financial loss, which you may not have to get into. If there's financial loss, then you've established your estoppel. But if you want then to quantify the remedy by reference to detrimental loss, you have to go further and say, well, what is its actual value? I think that's what we're trying to explore.
I prefer you to answer the question than I want to ask.
Well, what we say is that if this was the contractual world, then there would be an agreement. It would be certain. Its terms would be certain. There would be a bargain. There would be an agreement. And consideration, one doesn't ever look at the materiality of the consideration. If there is consideration which is chosen as the consideration of the contract, then the contract is binding and it's enforced by the courts. But here, we're in a very different world. We may have emerged from there. I mean, Ramsden and Dyson was one of the historic cases, which is said to be the basis of this jurisdiction. And that to a certain extent relied on the concept of part performance in contracts, but then said there's a different category where it's not certain enough to be contract. And Lord Kingsdown, in his famous passage, cited that there were two alternatives. One was performing the promise, the other was compensating the loss, which is, so it has been the lively controversy ever since the 1870s or so when that case came in. In contract, you have a specific consideration, and that is enough to trigger a liability to perform the contract. But proprietary estoppel is very different. It's not good enough to say, well, there is some loss, there is some detriment, there is a large assurance, there is some detriment. That, therefore, means that one goes to immediately to the step of saying performance of the promise is the appropriate remedy. Because there must be another element of it, which the case repeatedly says, there must be proportionality between the detriment and the remedy. And that's
well, it's often put that there must be, and I'm not sure I quite understand what it means, but it's often put as being proportionality between the assurance and the detriment. Which, I mean, there either is or there isn't. There's nothing a court can do about it. But I think it's put in that way as meaning if there isn't proportionality between the assurance and the detriment, that gives a real cause to consider whether merely enforcing the insurance is the right remedy. Well, because that would automatically be disproportionate to the detriment.
Yes, exactly. That line of the way of expressing it is to show that if the expectation were to be the relief chosen, it would be disproportionate to the detriment, and therefore it should not be chosen, isn't it? Yes. There is confusion about how it's expressed in many of the cases. For instance, I think we may have repeated that confusion in our case, but if one looks at it's Jennings and Rice, because it is important to get this particular point right. Yes, Jennings and Rice. In Jennings and Rice, for instance, at page 1088 of our bundle, it's paragraph 36 of the judgment in that case, page 111 of the judgment. Lord Justice Aldous says, both the result and the reasoning of the judgment in Campbell are inconsistent with Vaughan's submission. There is a clear line of authority from at least Crabbe to the present day, which establishes that once the elements of proprietary estoppel are established and equity arises, the value of that equity will depend upon all the circumstances, including the expectation and detriment. Task of the court is to do justice. The most essential requirement is that there must be proportionality between the expectation and the detriment. Now, that's it's an impossibility. Right. And to his credit, Lord Justice Floyd, in this case, in the Court of Appeal, said, after the words expectation, he brackets semble remedy.
Yes.
And Lord Justice Walker deals with it. For instance, at page 1090, paragraph 47, if the claimant's expectations are uncertain, as with the case of many honest claimants, their specific vindication cannot be the appropriate test, but he deals with proportionality specifically. In paragraph 56, I think it is on page 1092 of our
What do you say
Bible.
about that sentence at the beginning of paragraph 47? do you say that in these farming cases where necessarily the assurance has been made many years before it's expected that the promise will have to be fulfilled, and we know there's all sorts of things that can happen, are you saying that in these farming cases the expectations are always uncertain, so that then their specific vindication cannot be the appropriate test? I mean, you said these farming cases form a category because they're based on an expectation of inheritance many years in the future.
Yes.
Is that then the sentence you rely on as establishing a principle, at least for these cases, if not for proprietary estoppel more generally?
But we say that, but it's not quite that easy. Some of the farming cases involve, for instance, a nephew who is brought in onto the farm on the basis of a specific bargain, effectively. And there is even Haberfield, which I think is the daughter, where the courts were clear that that was a quasi-contractual claim. A bargain had been made. So some of the farming cases, they do it. The family say, well, I had a case where the nephew had a very, very good job, very nice house. And his aunt said, it's time to come down to my farm. And they worked out what the bargain was there. But very much in the case of this kind, where you're the son growing up on your parents' farm, and you go into that, you make your assumptions. In this case, the judge said he made his assumptions up to 1997, I think it was, and then realised from 97 onwards, actually, the assumption that he would inherit it all was wrong. He was going to be sharing it with his siblings. And that was the aspiration of everybody. Yes, there was no bargain. So it was absolutely uncertain, and the specific indication cannot be the appropriate test. You say absolutely right. So I was just going to show you, and Lord Justice Walker's other reference to proportionality, which is at paragraph 56. I respectfully agree with the view expressed by Lord Justice Hobhouse and Sledmore and Dalby. Principle of proportionality between remedy and detriment, emphasised by Mason and Vervain, is relevant in England also. Lord Justice observes.
Well, that's a different point, and that's entirely understandable. Once you've identified what you're trying to remedy as the detriment, then you obviously have to try and, as best you can, to fashion the remedy in a way which will match the detriment.
Yes.
Well, what it says is there's a principle of proportionality between remedy and detriment.
It does say that, yes.
And therefore, what one should do is one should be looking to assess the detriment in the case, and then make sure that the remedy you've got is proportionate to that. So that is a simple and we submit clear guidance.
It doesn't Lord Justice Walker mean when he says proportionality, taking due account of all the appropriate deductions that ought to be made from giving effect to the promise as it stands on its face? Because here, and I would like you to address this, the judge goes straight from saying that there is effectively a proprietary estoppel to saying there has to be a clean break, and then he says, the regrettable fact is that the loss of tax is inevitable, or the sale is inevitable. He doesn't factor those in as points that might be used to say, well, in order to do the minimum equity, we have to take account of the fact that this will impose detriments on the other parties, and they should constitute factors which may reduce.
Well, you're absolutely right, with respect, and yet not a different part of the exercise we submit than the proportionality.
Well, that's what proportionality is all about.
Well, proportionality, like unconscionability, proportionality is one of those easy words to say, but a difficult word to pin down. So that I think there's one of the cases which actually flirts with it. It says that the financial loss was 200,000. The award was 1.2 or 1.4 million. How is £200,000 proportionate to 1.2 million? And no simple answer was given. What is meant by proportionate? It's proportionate in my submission, in this case. What it must mean is roughly equivalent, in the same ballpark, is a rather ugly and not very legal phrase.
When all the matters which the judge, in exercising the discretion, for the purposes of achieving the minimum equity, has made deductions.
Yes.
Or whatever he needs to do. It might be an increment, but...
Yes, adjustments or whatever, yes.
There's a difference between applying a general proportionality test, in which case the difference between expectation-based and reliance-based it may well reduce, to having what some of the cases seem to indicate, which is a sort of sense check, as it were, is fulfilling the expectation out of all proportion to the detriment. But to use the word proportionate as a shorthand for not being out of all proportion to is not quite what we usually mean by the word proportionate.
No.
So I think that
No,
may
you're
be
absolutely
where
right.
the confusion has come in.
I entirely agree that the confusion has come in there. To say that something must be proportionate, to say that the remedy, there must be proportionality between the remedy and detriment, isn't saying is something out of all proportion. Out of all proportion is a much more extreme concept, and it's often easy to say, oh, something's not out of all proportion, but that doesn't necessarily mean it's at the same time proportional.
But you don't get, do you, from that, from paragraph 56, since we're still on Jennings and Rice, Lord Justice Walker sort of departing from the concept of fulfilling the expectation, just looking at detriment, because if you look at the quote from Lord Hobhouse the quote from Lord Hobhouse on the next page is to say little more than the end result must be a just one, having regard to the assumption made by the party association and the detriment which is experienced.
Yes.
In other words, it's saying you've got to look at both.
Yes.
At least Robert Walker, Lord Justice Robert Walker is saying you've got to look at both.
Yes.
And you don't just abandon the fulfilment of the expectation. For example, if that's not disproportionate to the detriment.
It must be a just one, having regard to the assumption. So the assumption is in a sense, the background. What is assumption? You obviously can't exceed the assumption, and that's relatively clear. That's one of the few things, limits I think is relatively clear.
That's a cap.
Thank you. So, and in Lord Walker's terms, he calls it the maximum, and you identify the maximum, and then once you've identified the maximum, you go on to see what is the minimum. That's the way Lord Walker expresses it. And so that you have regard to the assumption.
But the minimum for what? I mean, we have to have a coherent principle here, and I'm not getting much help from you at the moment. I was hoping you'd be, at some point, producing some sustained, argument or propositions. I know we're asking you questions, but I'm looking for a principled explanation from you as to how we go about these cases, rather than just picking out a quote here or there.
But our submission is that you use the minimum.
How do you arrive at the minimum?
Minimum relief, and you arrive at that by calculating in financial terms what it is that the detriment has been.
So the minimum is a detriment?
Yeah, absolutely.
But you don't necessarily, I mean, the calculation in financial terms of the detriment always produces, I suppose, a sum of money.
Yes.
But you're not, I think, saying, and therefore you only ever make a monetary award. Or are you?
Oh, no, we are.
You're saying that the remedy
the monetary award
proprietary estoppel is only ever a monetary award.
It should be a monetary award. It is. It should be a monetary award. It can be a proprietary award to reflect the value of money. Yes. But if you are going to give more than that, on what basis are you giving more? That is the essentially the jump. In this case, imagine in this case that we weren't doing it. We weren't looking at it now. We were waiting until the death, and the will had been changed to say, for instance, that my son Andrew is no longer on the farm. We had hoped he would be on the farm, and we recognise that he has earned less than he would have done if he'd gone elsewhere. So we give him £350,000 legacy to make good that loss. We say that had that been done, there would be no unconscionability because his financial loss would have been whitewashed clear by the terms of the will, and there would be no grounds for a proprietary estoppel claim. Now, he would then say, well, I could have done something different. But could have done something different has been measured in financial terms of the extra amount he would have earned if he'd been...
You started off with that point, but I'm still... I mean, even if you say it's a financial thing, all right, there are two ways you can do it. You can start with fulfilling the expectation, which is he gets the farm, and you can make deductions from that, a deduction from acceleration, a deduction for the fact that all sorts of things that could have legitimately happened that would have led to him not getting anything, and you arrive at a monetary value. Or you can do it the opposite way around. You can say, well, this is his financial loss. Let's add on some sum to reflect the fact that he could have built up his own business, he could have done other things. Courts are used to putting money figures on things that are inherently unquantifiable. Let's build up the loss from there, and then you say, okay, let's give him that sum of money, or let's give him a charge on the house if we don't want the farm to have to be sold. What I think we're all looking for is, you seem to be saying, let's do the second of those. You start from loss, and you build it up or don't build it up. I think what we're struggling is, why do you say that? What is the principal basis behind approaching it from that point? Because the Court of Appeal said that's not the key to this cause of action. This cause of action is not about loss. This cause of action is about promises and keeping promises when it's unconscionable to resile from them. So why do you say that the principle is you arrive at the financial sum from the detriment built up rather than from the expectation reduced?
Lady, I'm sorry, I'm obviously not making myself clear enough, but the reasons we say that are, one, that this isn't contract, which is, and it's the contractual framework where you give effect to bargains because of certainty of the contract, the consideration as being the key. We're not in that world. We are in a world where the question is, how do we avoid unconscionability? And you avoid unconscionability by providing a relief which gives a fair result, which gives a result which people say, well, there's nothing unconscionable about that. And that, we say, is linked to detriment, because it's the detriment which gives rise to the claim in the first place. So it's those two aspects of it. And the fact that, if one looks at the authorities say that one does the minimum to do justice. It doesn't say, well, you've identified the maximum and then reduce it.
You've identified the minimum as the detriment. That is just a circular argument. Why find out what the maximum is in order to arrive at the minimum?
Yes,
the sequence of questions where you identify the maximum, you go on to decide what is the minimum, and then you told me that the minimum was the detriment. Well, why go through those
The maximum gives you a cap. It sets out essentially it matches the assurance. And then once you've got that as one end of one potential limit, which you don't go beyond, you then, according to Lord Justice Walker, identify what is the minimum equity which does justice, the minimum relief which does justice, and which is proportionate to the detriment. So that fixes it, we say, very firmly in that particular spot. There is a difficulty, I accept, Your Lordship raised about non-financial detriment. But in my submission, the court is used to putting financial figures on detriment. The loss of a limb, pain and suffering, these things which are clearly not financial, the court puts a financial figure on them, obviously in very different contexts. But in my submission, where you can find detriment which is real, the court should be putting a figure on it. Yes, I accept that. But what you can't just do is say, well, this position went on for 3 decades rather than 1 decade. Therefore, we're going to bump a figure up from, say, 360 up to 1.4 million. That has no coherence. The fact that something went on for a period of time is already, we say, measured by the calculation of the losses you've looked at.
I take your point that there are forms of non-financial loss upon which the court, if it has to, for example, because it's a common law court which can only award damage, place a value. But in this context, where the court is not by its jurisdiction so constrained, how do you value, for example, the desire of someone who's been born in a particular property and spent all their life there to inherit it after their parent dies, because it's where they've always been? How do you put a value on something like that in circumstances where simply fulfilling the assurance and giving them the appropriate interest in the property will solve the problem without going through that mentally difficult process?
Because
I mean, an objective view might be that there's nothing rational in that desire to stay in that place. But nobody would doubt that people will incur a great deal of detriment in order to do so. Yes. What they want is not compensation for the detriment. They want they want the fulfillment of the expectation.
Well, yes, but that, what proprietary estoppel is not about. It's not about the loss of that hope. It's not about that expectation or desire being taken away from you. And Lord Walker makes the point in a speech he made to the Chancery Bar Association that what we're doing here is we are remedying unconscionability. And that's not the fact that you've lived your life in the hope of inheriting. An awful lot of people live their lives in the hope of inheriting. An awful lot of people live their lives in the hope of inheriting on the basis of assurances they've received from their parents and grandparents.
But the unconscionability is not merely that they've suffered a detriment, i.e. they've behaved in a way that they wouldn't otherwise have behaved. It's they've suffered a detriment on the expectation of the insurance being made good.
Yes, and the detriment is not the fact that they haven't got it at the end. That's not the detriment. The detriment is what they've suffered over the period, over the intervening period. And you cannot use the disappointment of not obtaining what had long been hoped for as itself the key to somehow...
You can't use the disappointment on that way of looking at it, but you can say, can't you, that somebody has spent 30 years, part of the detriment they suffer is having had based their life around a prospect which is then not fulfilled, and the detriment is having that dashed, so to speak, whereas if they hadn't been encouraged in the first place, they would have centred their life and the value they attach to things on a different opportunity or a different way of living. And that detriment, the loss of the opportunity to do that, and instead to have committed themselves to what turned out to be a dead end, that's part of what you have to remedy when you remedy the detriment.
First of all, the fact that the hopes are dashed at the end, we submit, is not part of the detriment which we look at. It's not part of the unconscionability test. But in any event, if you look at a case of this sort, he's not going to get the farm. He was never given more than a percentage of it, and the farm would have to be sold.
No, sure, but if he the detriment is that he has not, if you like, he has not centred his life around another set of ambitions and job opportunities, and he's lost that and ended up in a position now where it's very late in life to do so.
My Lord, that is, I accept, some of the thinking that appears to emerge from the cases. But in a case of this sort, there was no other relative who owned a farm who he could go and work for on the basis of a promise from them. There's no immediately identical counterfactual. The only counterfactual would be go and work on somebody else's farm with no prospect of, just working there. And you might even try and rent your own farm, but you're not going to be able to buy that freehold because you're not going to be able to build up the capital to afford to buy that freehold. And in fact, he was offered the opportunity to rent this farm at a discount, 2/3 of the rent he was offered. And he turned that down. So he had that potential counterfactual, if you like, offered to him on a plate and didn't take it for his reasons, whatever they were. So we say that no, you don't look at that. If you can say there is a different path which we can identify, and that does happen in these cases. Hey, from one's own experience, the client who has a different job in a different place, and is called back into the farm, he's given something up, then you can look at that and see how that would have developed. But it doesn't develop. There's no way it develops that he becomes the owner of a farm, even less the owner of this family farm. He has left the family farm. He chose to leave it. He left it, and he's now preventing himself from inheriting it, or even his siblings from inheriting it by bringing this action. So we suggest that just doesn't apply in this case, but in a sense doesn't apply in any of the cases. The shattering of the dreams is not the basis or proper rational basis on which proprietary estoppel can be conducted. You have my case in front of you. I'm not going to start going back to where I would have jumped in had we not been discussing these matters. But it may be that best if we pick it up at page 119, paragraph 111, just to make sure that I've got the arguments I wanted to put before you on the minimum, why we say the minimum equity is the correct approach. It's 111, and I've given a number. 112.
Paragraph 111 of your case.
Yes, it is. Sorry, it's paragraph 111 of the case, page 119 of the bundle. And we say that the minimum equity is the correct approach and should be given real meaning. Should further be done by a reliance-based approach to relief, which is its natural bedfellow. Several further points may be made. One, I've already made a number of times 112 about what's necessary to avoid an unconscionable result. Snell puts it well at the bottom of page. We quote 112, paragraph 112. If as a result of that course of conduct, there's reliance by B on a promise made by A that B will acquire a right in relation to his property, B will then suffer a detriment, or A to be wholly free to renege on that promise, it comes in the liability to ensure that B suffers no such detriment. Satisfying the equity is, we say, is to address the detriment not to meet the expectation, 113. Contract unhelpful, 114, and 115. We say the point has been put most eloquently in a line of Australian cases which have been adopted in English cases. We refer to Grunt there in great boulder property gold mines, where one condition appears always to be indispensable, that other must have so acted or abstained from acting upon the footing of the state of affairs assumed that he would suffer a detriment if the opposite party afterwards allowed to set up rights against him inconsistent with the assumption.
I'm so sorry, where are you, Mr. Dumont?
I'm sorry, I'm paragraph 116, towards the bottom of 120.
Thank you.
And I'm reading rather badly, I'm afraid, because I slightly lost its thrust, the quote from Grunt.
Yeah.
One condition always appears to be indispensable. The other must have so acted or abstained from acting upon the footing of the state of affairs assumed that he would suffer a detriment if the opposite party afterwards allowed to set up rights against him inconsistent with the assumption. So long as the assumption is adhered to, the party who altered his situation upon the faith of it cannot complain. Well, obviously not. His complaint is that when afterwards the other party makes a different set of affairs the basis of assertion of right against him, if it's allowed, then his own original change of position will operate as a detriment. So that refers back to the change of position, the original change of position on the basis of the assurance, not to the snatching away of the promise itself, although that's the trigger. Over the page 121, we refer to Verveyen and Slebaldor. We've seen that, but in Verveyen, McHugh said forceful promises, province of contract, equitable aimed at preventing unconscionable conduct, seeks to prevent detriment to the promisee and so on. Walton Stores and Mayer, we give a quote there. If we started 4 lines down try and take it more quickly, towards the end of that line, then the object of the principle can be seen to be the avoidance of that detriment, and the satisfaction of the equity calls for the enforcement of a promise only as a means of avoiding the detriment, and only to the extent necessary to achieve that object. Gray, there's considerable force in the argument excitation-based estoppel threatens an improper outflanking of the requirement for contractual consideration. Over the page 122, secondly, some of the minimum equity and reliance-based approaches are consistent with one another, providing a coherent approach to relief. Aim is to find the irreducible minimum amount of compensation which would remove the unconscionability. I think I've made that point enough already. Thirdly, paragraph 121, page 122. Coherent and comprehensive approach dispenses with the unconvincing dichotomy between the quasi-bargain and other cases drawn by Walker and Jennings, criticised, possibly moved away from.
I don't understand that. I would have thought it increases the difference between the quasi-bargain cases and these cases, because I think in the quasi-bargain cases, then the result is that you do get an expectation-based remedy, or are you saying?
No, on reflection, I fear that you may be right. I fear my thinking ought to have developed on from the case, because the quasi-bargain case, it's a little like the original in Ramsden Bison is itself we're almost in the world of contract. There is no. An agreement was reached. It may not be quite certain enough to be an oral contract, and nowadays, of course, contracts can't be any more oral. They have to be in writing. But it may be that those cases are, in a sense, rather simpler and easier to deal with.
And then proportionality comes in a quite common case where an elderly person perhaps doesn't know the value of the property that they're living in or the value of their estate. They think it's not worth very much and they promise it to a carer who they can't afford to pay a wage to.
Yep.
But then it turns out that the flat they're living in is worth £2 million.
Yes.
Then you would apply.
Then you apply proportionality as a cross check. Yes.
But that's not the kind of thing you're suggesting that we do in this case.
No, it isn't.
Well, there's another way of looking at those cases, which is the way McFarlane looks at them, as I understand it, which is to say that in a case where there's been some sort of discussion about it and a reciprocal arrangement made, then if the person incurs the detriment, a fair measure of it is, if a good way of valuing it is to see what was agreed that detriment was worth.
Yes.
But if somebody pulls out of the quasi-contract, as it were, after a couple of months and the detriment hasn't been incurred, well, then they're not going to get what was promised. So it isn't actually delivering on the promise, it's quantifying the detriment. Well, that's McFarlane's analysis.
Yes.
But I don't know whether you're supporting that or not. I'm not quite sure what you are saying on this subject at the moment.
Well, I'm saying in relation to the quasi-contractual cases, it's in a sense easier for our purposes to put those to one side and deal with them in a particular way because they have a specific context and their own requirements. And one example, running for what your ladyship said, is that the person who asks for somebody to come and work as their carer, that person gives up the job, goes in, but the elderly person dies within a month, say. The job is still available to the carer, they can get back to it, and yet they have performed completely the bargain. So the answer there would be, well, even though there was a clear, crisp bargain, it's completely disproportionate to recognise it in that way. Fourthly, I say paragraph 1, 2, 3. It's submitted the logic leading Lord Justice Davis to favour the reliance-based approach is impeccable. Detriment is a fundamental element to establishing the equity. To remove that element will necessarily satisfy the equity. The fifthly, we talk about where it's got further support, and that's Lord Justice Henderson, though careful to show he was in more that he was not finally deciding that. And we look at 6 and 7 is the support that this approach has elsewhere, although it's true to say that in Australia that support is receding. We refer to a number of articles there, which may be of some assistance, but in particular, I think that 1.1 on bottom of page 125 of our case 126.6, Wilkin and Garley is the law of waiver, variation, and estoppel. He also expressed the view the prime aim of the remedy is avoiding detriment, the claimant, rather than fulfilling expectations. Quantum should, insofar as possible, be determined by reference to the nature and extent of detriment or reliance. And we refer also to Professor Mee, 126.8 and 126.9, who's got some trenchant things to say about the inadequacies of looking only at looking primarily at enforcing the expectation.
Sorry for taking you out of your way.
No,
Please don't go out of your way if it's inappropriate. But you refer at 126.5 to McFarlane's proposed test. And I was wondering whether or not that is the test which you are suggesting that we adopt.
Yes. Yes, my lord. I hope that's the way I've expressed it before. If you've had to ask me, then perhaps I haven't been as plain as I could be. But yes, that is exactly what we're.
Thank you very much indeed. Thank you.
And On page 127 of our case, paragraph 128 and 129, we pick up...
Would you accept that that doesn't rule out giving some or putting some rough and ready value on a non-financial detriment in a case where such a detriment has arisen? I realise you say detriment doesn't include shattered dreams and there was no such detriment here, but in some cases there is.
Yes.
And the courts may put some apparently random value on that, the advantage of which is that then cases are more likely to settle because everyone knows the maximum that you're going to get for that kind of disappointment is, I don't know, £10,000, a bit like the sort of Vento guidelines, trying to put monetary values on things that can't be valued in a way that takes out the dispute about the valuation.
I cannot say that there are no considerations, there's no non-financial detriment which could be brought into the equation. It's impossible to rule out all possibilities, but what I try to say is that the mere passing of time, I say mere, it's the passing of time, the lifetime spent is itself not the sort of thing which should be factored in as financial detriment. I had a case myself where the father, his daughter who'd been looking after him was due to go on a liner to the United States to get married. He sent a message to the liner that he had a heart attack. She rushed back. She missed her boat. Her husband said, "Well, I'm not. It's off. We can't." She never remarried. There are certain factors and characteristics which do seem to be wretched and might be brought into account in some way or other. Whether that is one, in general, one should regard all these any non-financial submission with great care and see whether actually a figure could be put on it, or if not, whether in fact it is a real detriment that should be taken into account at all. Yes, I'm sorry, page 127 of our case, at paragraphs 128 to 129. I just deal with the question of fault. It's sometimes said that where there's difficulty in calculating loss, or where there is some kind of non-financial loss which the court is feeling it ought to be putting in the mix, because it's the fault of the defendant that the expectation has not been satisfied because they've reneged on the deal or reneged on an insurance, that therefore that quantification must be decided against that person. Any presumption or valuation must be against their interest. They can't say you can't put a value on that because they are at fault. But in so many of these cases, fault is entirely the wrong term to use. And undoubtedly, in this case, fault is the wrong term to be used. The two parties, Andrew left the farm. He fell out, first of all, with his brother, but then fell out, more importantly, with his father. And the judge did not apportion any fault to that. He recognised that that was just what happened between those two individuals. So fault is very rarely of any assistance and doesn't give any assistance in this case, we say. We also point out in 134 that there is, 90, there's no logic to the doctrine where the award varies according to the extent of the expectation and in turn the value of his estate, where they say subject matter of the promise. Imagine two claimants in different cases who make the same sacrifice and suffer the same detriment, therefore raise a very similar equity to be satisfied. On an expectation basis, they could receive entirely different awards depending on the value of the estate when it comes to trial. Now, I know that's a somewhat legalistic submission, but it's still a valid one. That if you each worked for $250,000 or so, less than you would have got if you got elsewhere, the expectation which is going to be fulfilled might be a farm worth $1 million, a farm worth $2 million, a farm worth $3 million. How is it that that gives a very clear picture that there is a distinction, there is a lack of correlation between detriment and relief if the awards can vary so much. Tenthly, it's submitted that the minimum equity reliance-based approach is the only approach that can provide a structured and inherently proportionate response in cases which involve long-term commitments. Otherwise, even in the quasi-bargain case, what is left, there's no statutory guidance. Well, we've looked at quasi-bargain cases already. The 143, paragraph 143 on page 130, we come to 11thly, submitted the perceived difficulty in assessing judgment cases where it's been held the representatives position their whole lives on the promise is far from being an insuperable obstacle, and that's, I've already hope.
Obviously, we've all read your case, Mr. Dumont. I mean, you can read it out again to us if you think that's the most constructive use of your time, but normally in oral advocacy, it's a chance to make some submissions that, you know, aren't just reading off the page.
Well, yes, I accept that. But of course, I've tried to get all our submissions into the case as well. So I'm just trying to, as it were, make sure that I've got them where I want them. But if we look perhaps somewhat further on at our particular case, what we say about this particular case, we've mentioned in the factual point, an earlier part of the case, but we say it is vivid in this case that my client's father took on the lease of this property when he was a young man in the 30s. A few years later, his son, my client David, was born. At the time when he was 19 or 20, his father died when he was still a tenant. The landlord called them in, and him and his mother in. They rather expected they might be thrown off the property, but they were offered the property themselves then. And they decided to take it, and they raised the money by mortgage to buy that property. They worked hard, he and his mother and his wife, his wife had gone to the farm before the father died, when she was in her mid-teens, and worked there. She milked the cows, she did other farming jobs. They all worked hard, and it was their farm. They worked for it, they borrowed the money, they paid off the mortgage, they worked all the way through. In 1981, he made his will, David made his will, carefully considered will. At that time, it was a clear intention in his will that his children should be able to take over the farm on his death. At that time, Andrew was, I think, 15 or 16. Ross was about 3 or 4. So he was looking, it was his aspiration. He was looking very much forward. He never told his children the terms of his will. That was kept as a private matter, but that's what he wanted. The children then assume that they will inherit as he did intend. The years roll by with the family working together. We know from the judgment from 2000 onwards that Andrew, the claimant, was actually paid more than his father. For the work he was doing, he got a higher income from the farm than his father did, or his brother. So that the family farm was run by the family, and the income, the profit that farm generated, was divided on a fair basis among the family, with actually Andrew getting slightly more, but I think it's about maybe 25% or so, more than his father. So, although he would say that on the counterfactual, I might have got more elsewhere, within the farm it wasn't one of those sort of paradigm cases where somebody's made to work for nothing, as happens, or work for very, very, very little. You can't have more money because you're going to get the farm one day. It's Walton and Walton, I think, isn't it? But it wasn't like that at all. Then there were difficulties which were identified with Ross, Andrew and his brother Ross working together. They'd run another business on the land, which doesn't, the financial benefits of that don't sadly feature in the trial judge's judgment. He may not have had them before him. They run another business on the land. They haven't been able to run that adequately together. So
that's one of the things that concerns me. The fact that the business that there's running on the land, whether it's the farming business or the solar energy farm or the quad biking or the paintballing, that's being, Andrew would say, subsidised by that business not having to support a proper salary for a person who is needed to run it. And that's a sort of wider concern that I have with these cases, that the businesses that are being run on this land are not actually profitable enough to support a proper salary for the people who are required to work on the land in order to run the business. And if there's a next door farm which also wants to run a quad bike business in competition with Tump Farm, but doesn't have a son who's prepared to work for less, assuming he's working for less, then that kind of skews the way that the land is used, doesn't it? It seems to be perpetuating a kind of depression of agricultural wages and a use of the land which is not actually economic if you have to pay the people properly for running the business.
The farm is only as big as it is. The amount Andrew says he's paid less than he would have got.
Well, just assume for the purpose of my point that he is being paid less.
Yes, and the amount he says he's being paid less, which he quantifies as £360,000 over the period, would also, one assumes, be the extra money that would have needed to be spent if they'd had to hire in the same person, so for somebody from outside. So it reflects the same aspect. But you're absolutely right. If this farm cannot generate any greater income, it cannot generate any greater income. And he is being given more of the income than either his father or his brother. The adjoining farms in this case, oddly enough, the adjoining farms in this case were rented by the guests. David and Josephine rented the farm next door, which
yes,
Ross
I'm thinking of a
occupied.
more hypothetical instance than this actual neighbouring farm.
But when they rented those farms adjoining, that itself creates a burden, because not only they've got to pay the rent in order to get their profit, whereas on their own farm there is no such rent. Yes, the solar panel is a separate issue, but the solar panel, the rental of the solar panel is £1,000 an acre, and my instruction is no brainer to accept that, because you cannot make £1,000 an acre on this farm otherwise. So you take that because it's the money, and B, it requires absolutely no work at all. So that should be done. But yes.
And I suppose these are the economics of farming, aren't they? I mean, that in this you may have a choice in life between going off to earn more money or earning very little, if that's what the farm will generate, with, in compensation, if you see it that way, for that, the satisfaction of running your own place and owning your own property.
Well, prospectively owning your own property, yes.
Well, yeah, I know, but I'm just looking at it not in this as a choice in life.
Absolutely right. And in a sense, you think you're your own boss. You discover you're not, because your father is the boss. And if you remember the specific assurances, the only specific assurances which could be brought before the court were father saying to son, when they're discussing some machinery that some thought it would be a good idea to buy, father's saying, it's my farm. When you take over, you can do what you want. It's father saying that this is the way I want it. Now, you may find yourself better positioned choosing to work with your father than working with as a tenant or employee, even worse, to some other farm. And indeed, in this case, when Andrew went and left the farm, the first permanent job he got, he was dismissed from within a year. He appealed against that. He no doubt thought it was unreasonable that he'd been dismissed, but wasn't successful. The outside world can be a difficult place. No doubt about that. And the idea of assuming that the outside world offers milk and honey necessarily sufficient to bump up a detrimental loss to an expectation loss, in my submission, is a step too far. One that should not be accepted by the courts.
But part of what he lost, and even on your approach should be fully compensated, is the chance to build himself up from a younger age when it was easier to do so than having to make that transition and find a new job 30 years along the track.
Well, it's still a job. It's still a job.
Of course.
And he himself said in 2014, we have his own words, I could be earning £30,000 and have a car, and my council tax paid. And he left the next year, and he found a job earning £33,000 a year with his accommodation and so on. So even on his own estimate of where he should have been, he was there. It's not, the farming world is not, as I understand it, a world where you build up a career and you end with golden handshakes and six-figure salaries. As a farm manager, it doesn't work that way. So the counterfactual, we say, is still readily accessible. Clean break, something I need to deal with in this case, because it is said that in cases where there is where there is a need for a clean break, that one has to, even before death, one cannot let things rumble on. And there's a passage in Moore, I can just take you to that, which deals with that very succinctly. It's in the bundle, it's page 1126. It's page 1308 of the report itself, down towards the bottom of the page. No, it's not. Just the page before that, I'm sorry. It's page 1125, again towards the bottom of the page. At H, Lord Justice Henderson has described the breakdown in family relations. The parties become increasingly entrenched over the last 9 years. All attempts to resolve dispute amicably have failed. The rift between the mother and the son regrettably seems deeper than ever. In those circumstances, the need for a clean break solution is, in my view, compelling. As Lord Justice Robert Walker said in Jennings and Rice, the courts cannot compel people who have fallen out to live peaceably together. Although no doubt primarily directed to cases where the warring parties are living under the same roof, the practical wisdom of this recognition applies with the same or scarcely less force in situations where they are living in close proximity to each other and in a relationship of continued financial dependence.
I'm sorry, Mr. Dumont, I seem to be on the wrong paragraph. Which one are you on?
Sorry, it's paragraph 93.
93, thank you.
Bottom of page 1125.
That's all right, yeah.
But in that case, there was a partnership, which if they hadn't got the notice right first time, no doubt could have been rectified. The notice could have been rectified, which means there'd be immediate dissolution. I mean, that's got a legal framework to it. The difficulty about the judge's way of approaching a clean break is to treat it almost as if this is a divorce, which you have to give effect to the break in the family.
Yes.
It doesn't necessarily follow from the fact that there's been unconscionable conduct, or is expected to be unconscionable conduct, that there should be a clean break. You have to do simply that which is necessary to give effect, to reverse the unconscionable conduct.
Yes, exactly. In more and more, they were living absolutely next door to each other, as I understand it, and the financial independence was quite acute in that even as a result of the judgment, there would be continued financial independence because orders were made by the judge for payments to be made by the son to the mother, which would themselves be a ripe cause of dispute. But before that, there was a partnership and there was the interdependence. Here, absolutely not. Andrew left the property in 2015, hasn't lived in the adjoining granary cottage since then, hasn't worked on the farm since then. They have gone their separate ways. There is no justification on this basis for the so-called clean break.
Well, that goes beyond the minimum equity, you would say.
Goes beyond
the minimum equity.
Yes, absolutely.
But the clean break here is not that kind of clean break. The clean break is that there seems to be a mismatch between what your client's expectations as to the consequences of the remedy ordered and the Court of Appeal's thought about what the remedy would, how it would be implemented. There may be a mismatch, because I thought that you were saying that there needs to be a financial remedy. You calculate it in whatever way, and then there has to be a monetary payment. Then the question is, the clean break comes in saying, and that must be paid now, even if it means that the farm has to be sold. And not having a clean break means that the parents can go on living there, the land doesn't have to be sold, and the money only has to be produced at some later stage. I think that's what we're talking about in terms of clean break or not clean break. So what's your case on that? What is that actually you're saying? Well, there doesn't need to be a clean break because they're not on top of each other and fighting. But as far as the implementation of the remedy is concerned, how does clean break operate in that context?
Well, the assurance was never more than that he would have an ownership interest on the survivor of his parents' death. So that
was it quite as little as that? I mean, the assurance, as I understand it, was that he would in due course come to be able to run the farm himself, and on his father's death, inherit a sufficient slice of it to underpin the assurance of his running it. But the assurance that he would run it was in a sense one which would be expected to trigger on the father's retirement rather than his death. Although, of course, there are plenty of farmers who work until their dying day.
yes.
And as I understand it, the judge's approach to clean break was rather more saying, well, we can't obviously construct an arrangement under which son is entitled to run this farm while father's still alive and living there.
Well, yes, but he'd also already gone and was making an income, which was the income he said he ought to be making.
But one needs to analyse this, because on your case, that if you're right that it's detriment, then that needs to be paid out now, doesn't it? Because the detriment has been suffered, and indeed, then he's not only to be the extra money he would have been making 20 years ago, but interest on that for the fact he's getting it late. This arises, this clean break, if you're wrong in your analysis, and the starting point is the expectation, and you say his expectation then was largely future, and a different remedy should be crafted. But that surely is an alternative position for you.
In fact, no. We say that if a detriment has been suffered, since he would never have received under the assurance the proprietary interest which he claims will wipe out that detriment. He cannot get it accelerated. He cannot have his money back now. He can't just cash in and say, I want my money now. And he would only get to the detriment he would receive on the second death. That's when he receives it, the financial detriment.
Well, that's a nonsense, because he suffered the detriment already.
Yes, but he was suffering.
And so therefore, if now is the time when he's not going to get the promise, which it is, because it's clear he's not going to get what's promised. So now's the time his detriment must be wiped out.
But surely you're saying that you have to do only the minimum equity, which is not necessarily reversing the detriment.
Well,
exactly, but he hasn't got the right to cash in his detriment. We say the detriment is he's never going to get the ownership interest, which is the valuable interest until death. What right has he got to cash it in now?
Well, that's incoherent, because you say that it's the change of position that he's made which needs to be remedied,
yes.
And he's made that change of position, and that's in the past.
But if he
it's the expectation that's in the future, but on your analysis, he's not going to get that.
But had he stayed at the farm until death, the detriment would have kept on building up.
Well, then it would, and then there'd be more to compensate. But actually, it hasn't. So it's now's the time we quantify what he's suffered.
Finite amount now.
I mean, isn't the case that the judge shouldn't have accelerated the benefit essentially based upon the notion that the son is getting more than what he was given to expect? In other words, it exceeds the cap.
Yep.
To which I imagine your opponent will say, well, yes, but it was subject to reducing the figure by reference to the father's life interest in the farm. So it uses a suitably discounted figure,
only in the house.
a discount for early receipt based upon precisely that which he was going to have to wait for anyway.
Yep. But
I mean, what do you say about that? That the element of acceleration is dealt with by making sure that the valuation, even if the farm has to be sold, what he gets is discounted by reference to a notional life interest for the father.
we say that doesn't come close to respecting the proprietary interest of the father, which he's built up over many years.
Why not? You say all these things can be valued, and if it hasn't yet been valued, as I understand, that's still outstanding in this case. And if it doesn't come near, it's not a proper valuation, is it? I mean, either it does respect his proprietary interest, in which case the value will compensate for it, or it doesn't, in which case it can't be a full valuation of it.
It was a life interest in the farmhouse. Has anyone actually put...
Farmhouse, yes, exactly.
Has anybody actually got a value of what the life interest in the farmhouse is?
No.
We haven't got that far. But...
Yes, I'm corrected. It's the farmhouse.
I tried to correct you in full flow, but I didn't have my megaphone with me.
Well, do we have the value of the farmhouse? Not the life interest, but what it would be worth if sold now.
I think it's 285,000. Yeah, about £286,000, the farmhouse itself, in the valuation. But, so, I accept he has factored in that, but we say that that's still the wrong way to look at it, because although that has a legal recognition that my clients will stay there or are entitled to stay there, it is their house. We say it was always going to be theirs, and they're always going to stay there until their death. And to give them the valuation of a life interest in that house doesn't reflect the realities that they may need to sell it and pay nursing home fees and that sort of thing. There may be all sorts of issues which we say that just doesn't meet. So we said that it's not
entirely clear as what you're saying. The judge should have done, or the Court of Appeal should have done. You say they should have valued the detriment. That's just the difference in wages, and you don't add on anything for shattered dreams or for the fact that he worked for 3 decades, and you get to a lump sum, and I think you've said what that sum is. And then what? Because I thought part of your case was that you don't order the payment of that sum of money immediately if the result of that is going to be A, that the farm has to be sold, and B, that there's then a tax disadvantage, which means there's less money for everyone.
Exactly.
So what is it that you're saying?
We say that if you come to the conclusion that there is that figure, then that is charged on the farm.
Right.
And is then satisfied on death.
And not only has he lost that in the past, but he has to wait for it for another 20 years before he gets his detriment compensated.
Yes, but that reflects the fact that he was always going to have to wait.
No, he wasn't.
That period.
Because it's not the expectation. What he was going to have to wait for was the realisation of the expectation.
But in
the detriment is what he suffered in reliance on that hope. And so now that's something he suffered in the past, and he's never going to get back until it's remedied.
But the continuing, he has no continuing loss because he is now earning.
No, he's just got the past loss.
He has.
Well, he may have a continuing loss in the sense that had he started a separate career 20 years earlier, he'd be earning a great deal more than he is now.
Yes, he might.
Well, as to that, I responded by saying that his own statement in 2014 was, I would be earning £30,000 and having a car and a house, and that is what he has achieved. So that we say that while there may be outside possibility on his own evidence, that he is where he needs to be.
But are we not going about this in a holistic way when we should be breaking it down into separate exercises to say what the equity was and the extent of it, and then the remedy, the Crab and Aaron analysis? And in relation to the capital value of the farm, he doesn't have a present right to that for the reasons that you've given. And you could work it out, the present value of the ultimate capital value. The court would be able to give you a figure. But then you have to ask yourself, to achieve the minimum equity, should I award that capital sum to be paid now or later? And do I make assumptions such as what would have happened if it had still been within the estate of David and Josephine when they passed away? And that somehow has got to be taken into account. In other words, you've got to break this down into separate exercises. It's not just a matter of rewarding rewarding Andrew now for what he's lost. You've got also, first of all, to calculate precisely what he has lost.
Yes.
And then work out, as a matter of reversing unconscionable conduct, what is the appropriate way of paying compensation for that loss. And talking of the farm, I was making the point that was only his share of the farm was something he only got in the future. Therefore, you can discount back and find present value, but you've also got to take into account the situation that would have arisen if it had still been in the hands of David and Josephine when they died, and assuming the normal arrangement whereby the husband passes his interest to the wife, who becomes the widow, and she then disposes it on her death. You've got to do that complicated calculation, and then you've got to ask whether it's right to pay that now, order that to be paid now, or as opposed to the charge or whatever.
Melody, yes, there were a number of calculations and steps which weren't considered, maybe because there was not sufficient assistance to the judge at the trial, which might need to break it down. But what we were focusing on, as I understand it, was my submission here that if one takes it on the basis of the detrimental loss, then there's an issue as to when that needs to be paid. My submission is he's got no right to cash in. He was never going to get a stake in the property, an actual capital interest, until the survivor's death, and therefore it should be a charge to be satisfied there. If one takes a different view and says, well, there's got to be a capacity to exit from a proprietary estoppel, and I can see the attraction of that, because I can see that proprietary estoppel, if it sits as a dead hand, if there's no exit, if you cannot You cannot break it down as you might if it was a partnership or a company or something. If you're just stuck with it inflexibly, then that's an unattractive proposition. And that might therefore mean that one does give him the right to cash out, but or look at it the other way, give us the right to buy him out at this stage, with thus making sure that the litigation or the dispute doesn't fester.
Certainly the order ought to provide for an opportunity either to borrow the money or to come to some other arrangement, rather than to require an immediate sale, if that was the route going down. But I think the point is, what I was saying to you is exactly what you are saying to us, if I've understood it correctly. You work out what needs to be paid, and because it's a future sum, you have to consider whether it should be a charge only.
But it can only be a future sum if it's an expectation interest that you're compensating. Or fulfilling or remedying, whatever.
And indeed, if you do have both expectation and detriment as methods of calculating, you'd have to discount the expectation for acceleration. In order to find what the maximum is, you've got to discount the expectation for acceleration. And you also got to discount it for all the other vagaries of life, care costs, and also the farming enterprise failing. Not that there's any suggestion this one would have, but there are plenty. Yes, farming is uncertain. Yes. So was that A, argued, and B, decided?
I do not believe it was either argued or decided. Yeah. I'm afraid the submissions on relief were very, very limited. Yeah. Very, very limited. Yeah. And the judge had to do his best.
I mean, the case being presented against you is that they said what relief they wanted, but you didn't say what relief they should have if you lost on liability.
Yeah. Yeah. I'm afraid that's right.
Yes.
That doesn't absolve the judge from getting it right. He looked at the authorities, he considered them, he flagged up in his favour many of the issues that needed to be taken into account, but there was no explanation or justification or even apparent response to those issues when he made his final.
He could have directed accounts and inquiries.
Absolutely.
He didn't have to fix a figure right then.
Absolutely. And in fact, the result that he did his best to to impose was itself going to involve a process which would need to be continued.
Because
there were valuations which still need to be obtained in the sense of discounts.
And anyway, it could all be upended if the solution involved the sale of the farm, and that produced a different figure than what the value of the soil was going to produce.
Absolutely, and sale, and at those figures, a sale is really the only likely result on the judgment.
But was there any discussion about whether, on the figures, if it was sold, there would be enough money for the parents to find somewhere to live for the rest of their lives, for Andrew to have a workable farm, and for Ross and Jan to have something out of this as well?
I'm afraid that does not look like it was looked at all.
Well, that seems to me quite an important question.
Yes. It was Andrew's aspiration that he should, or rather his legal submissions at trial were that he might be able to obtain a replacement farm on, as it were, 40% of this one, somewhat after tax, perhaps optimistic, and certainly in the respondent's case now, they do accept that it's unlikely, I think, or may not be possible for him to get into farming with the figure that he's been awarded, which is leaves us in this rather odd position that the judge has fulfilled expectations, it said, because the expectation was he'd have a share in a farm that he would be able to run, but the financial outcome of the way the judge did that will not have that result.
If that had been known, then he might have said, well, the best thing to do is to wait until the interest matures in a normal way, i.e. when David and Joseph pass on.
That might be right. That would have had the advantage in saving the capital gains tax, which will be incurred when the property is sold, all has to be sold, and also ensuring that because it's within agricultural property relief, if that is not withdrawn.
Yes, what's the rate of agricultural property relief? What rate?
100%.
100%.
It's 50% if it's certain limited leases.
Yes.
But one always avoids that.
All right. So what the note is saying that we've got is that if it had been sold within the estate of David and Josephine, full agricultural property relief would have been available. But if it's sold now, there will be none, because obviously it's not passing under the estate. It will simply be the situation that capital gains tax is paid in the normal way.
Yes, capital gains tax is paid. We've got a figure somewhere between 125 and 225.
Yep.
It's difficult to
It's the
be
gain.
more certain of the range.
All right.
But on death, that's incurred now, which wouldn't be incurred at all. On death,
Well, there's a rebasing, isn't there, to then market?
yes, on death you would normally rebase, so that the capital gains during life wipes out.
But they won't still have it on death if they've sold it.
I'm sorry?
They won't still have it on death if they've sold it.
No, absolutely right.
But sorry, is that range figure, is that the tax or is that the gain?
That's the tax.
Right.
That's a tax. I'm sorry. If you did make that clear.
Which they'll have to pay in 1 year, as it were.
Yes.
Yeah. But what they have lost is the APR.
Yes.
Because when I say they and their estate
Yes.
and their heirs will have lost the APR.
Yes.
Yeah.
And Ross and Jan will be subject to inheritance tax.
They will. Yes.
Yeah. So their share will be taxed.
Yes.
Yeah.
Exactly.
Whereas his share
Comes in now.
will not be subject to
Not be
inheritance
subject to tax on their debt.
inheritance tax.
That's absolutely right.
Whereas what the judge is trying to do is to award the minimum equity to reverse the unconscionable conduct. So he's got to postulate what would have happened
Yes.
if events had gone as originally planned, which is that the estate would be in the farm would be in their estate when his parents passed on.
Yes.
Or his mother, if she was a survivor, or father, a survivor, so that he's got to make that notional calculation in order to find present value.
Yes. And if I give you indicative values, they're not conclusive values, because one can't judge now what the IHT will be on death. The rates may change, nil rate bands may alter, and so on. But a purely indicative value that is about £350,000 on the estate that they would be left with after the judge's order, the parents. So that when you add that to the capital gains tax, that has to be paid. The overall indicative figure for tax might be in the region of £500,000.
So you're saying if they sell the farm, the share that they get will then, let's assume that it's in their estate when they die as cash.
Yes.
Then that figure is what you say it will be, and Ross and Jan, assuming that they're the only beneficiaries, will then have to pay inheritance tax in the normal way.
Yes.
Whereas if it's the farm that's
Yes.
passed on, they don't have to pay inheritance.
And if they divest themselves of their property 7 years before they die, they have to be dependent on their son and their daughter.
But there's no reason for them to have a chargeable transaction like that, because they will get APR if they keep it in the estate with 100%. So there's no need for them to use the 7-year rule or whatever it is.
Absolutely right. Absolutely right. I don't know if his lordship was referring to if they do that with the cash once they've sold up.
Oh no, then it's different.
Which will be different. You then have some capacity for estate planning.
Sorry, I misunderstood.
But
only up to nil rate band.
Yes.
Sorry?
Only up to the nil rate band.
No.
If
you can guarantee you're going to live for 7 years, you can give away
What, any amount?
cash up to any amount without
Without any tax consequence?
Yes, that's absolutely right. It's only if you die within a 7-year period that the nil rate ban has to be then applied to it. Yes, but they have their own lives to look out for,
Yeah.
and may need this money, and there is limited scope for that.
So if the money was, as you suggest, if Andrew's remedy, if one gets over the difficulty that my Lord Legate highlighted of one sort of mashing together a reliance-based loss, but in these particular circumstances, because of how the tax works, placing it as a charge on the farm, then what happens if they do need to sell the farm for care costs? I suppose you have to have an ability to come back to the court to tinker with it in due course if things work out differently, or how does that work?
Well, I can see that if you could build in, you could factor in a provision that you come back, but I can see that if the farm is sold because they no longer want to live, they no longer want to own it, that's no longer a practical possibility. Then if there's a charge on there, then the obvious thing is to redeem that charge.
Yeah.
There's no real advantage in hanging it on and letting it carry over thereafter.
But the charge could be subordinated to proper living expenses. I mean, that's all got to be thought about and considered.
Yes, at the level we're talking about, that I'm submitting, there is no real issue about that.
No.
So that wouldn't be a practical
But
problem.
my lady was contemplating care costs, which can be very high.
It can be very, very high. It can be very, very high.
Mr. Norton, we're just coming up to your
I noticed that.
time limit.
I'm well aware. of that.
We're conscious that most of the time's been taken up answering our questions, but it's been no less useful on that account. I just have one question. If you're otherwise right, what are you suggesting we do? That we calculate the figure, or that we send it back for further accounts and inquiries? Or, I mean, what is your, bearing in mind that your side didn't assist the court much first time round on quantum, what are you suggesting we do about it if you're in principle right that the judge's order can't stand?
That is a matter which I've been giving considerable thought to, and I should have had a very, very clear answer, but I got caught up in other issues in relation to the case before I came.
It's not really fair to leave your answer until reply, because then Ms. Reid won't have an opportunity to comment.
I accept that. I accept that. In my submission, the best thing to do for all these parties would be to fix it at the £360,000. We're not entirely happy with that figure, but the costs of going on, both human and litigation, remitting it, would, in my submission, be ruinous.
So relief at £350,000 now?
Charged on the...
Oh, but only charged on the property?
Well, that's our solution. Yeah.
Will it carry interest?
That would be a matter for your lordship.
Well, I'm asking what your submission is. I realise it's a matter for us.
My submission, no, it hasn't carried interest so far. Why should it carry any interest? But I can see that there's that certainly wouldn't affect Lord Legate.
So I'm terribly sorry.
Where do we find this figure in the bundle?
It's an exhibit to the particulars of claim. Bundle 2. Thank you. It's page 421 to 423.
Oh, is that the page that you sent us through separately?
No.
Oh, okay.
No.
And where is it? What is it described as in the pleading?
It's exhibit AG1.
I see that, but what is AG1 in terms of what is it said to calculate? How does it feature in the claim?
It would have helped if it hadn't come out sideways on the bundle.
Yeah, but we could probably turn it
I
around.
can turn my laptop over.
I'm grateful. Page 417, 24 is the claimant reasonably relied to substantial detriment upon the representations, and 3 From the age of 16 years, he's been paid a very low wage without overtime, expected to work long, hard hours for very low pay because he's working his own farm. The schedule attached to these particulars set out the claimant's wages since 1982, AG1, but they also set out next to them the wages he says he should have received.
This is particulars of the detriment.
Yes.
Is interest built into it? And we're talking about going back an enormously long
There's no
way.
interest, no.
There's no interest built in.
So what is it, where do we, sorry, I'm looking at it sideways, but just so we understand what you say, the amount that he that he would have received, which is the
On page 40.
detriment's going to be the difference between what he did receive and what he would have received.
Page 423, the final figure in the bottom right-hand corner, if one's looking at it in landscape,
Yes.
is £360,467.
But this is comparing, isn't it, the AWB weekly rate?
Yes, yes.
Well, that's not what he says he should have received. He says he would have been paid 30,000 a year, or.
This is his claim, though.
Yes, but
But
in
he's
fact,
not presenting this as.
This is just particulars of part of his case that he suffered a detriment.
yes,
It's not his alternative claim for relief.
No.
no, he only had one claim for relief. But if one looks at the 2011 figure, for instance, it's 38,388. The next column in is what he says the AWB figure should be, which is that exceeds the £30,000 he talks about, or the 33,000 or 35,000.
But if you're adopting a purely detrimental approach, why shouldn't there be added in compensation for being kept out of money which he should have made in 1982 for best part of 40 years? At an appropriately
Probably on a
commercial rate of
compound
interest.
basis in equity.
And compounded, yeah.
But
That would double the figure,
I thought
wouldn't
your answer to that would be, because although he is his detriment that he incurred, he wasn't expecting to be paid for it. He was expecting to be rewarded for it in the future by the gift of the farm, and that's how
Expected to be washed out, effectively, when he got the farm.
But he wasn't. His claim is not that his loss of expectation is recouping an income detriment
No,
when he
I know,
gets the
but-
farm.
what's actually happening.
But a purely detrimental approach, compensating for his loss, would surely have interest have to be built into it.
If one looks at what happened within the farm, he received his wage, as it were. They all received their check each week, and he got more than the others. And that was all the farm could sustain. The farm could not sustain these figures.
Yeah. And you ran a no estoppel case at the trial and lost, and you haven't had permission to appeal. But on the footing that is part of the detriment which led the judge to conclude that there was a proprietary estoppel. You can't, as it were, go back and say, well, it wasn't really a detriment, can you?
No, I don't say it wasn't a detriment.
Anyway, I'm sorry, we've now questioned you over your time limit, but I was concerned to know what you're submitting we should be doing. But I've got it. You're saying it should be £350,000 charged on the farm, realisable only on either a sale of the farm or the death of the survivor of the appellants, and without interest.
Yes.
Thank you.
And as an alternative, if your lordship is saying that, if your lordship comes to the conclusion that there is it needs to be approached in a different way, the calculation, then that would need to be remitted.
That would
need to be remitted.
Or remit, yes.
I don't see how you can seriously put forward and invite us to accept a case based on detriment where you have to wait for years in the future to get paid your past loss and with no interest on it. I mean, that sort of submission just undermines the credibility of your arguments.
Yes.
Is that really what you're putting forward as a proposition for this court to accept?
Well, it is my submission, but if you don't accept it, then interest should be paid. Or it should be paid out now.
I just can't understand how, as a matter of logic, you can say that you should have to wait, because your whole burden of your submission is that this is not an expectation case, so we're not trying to value the future promise that he'd only come into in the future. We're trying to put him right for the wages that he would have earned through all these past years if he hadn't acted on the promise. All that loss which he suffered, and you're seriously submitting to us that he should have to wait for the compensation on your case and should not get any interest.
I am. Yes.
Right? Very good. Thank you.
Could I, just before we finish, just so I get my head around these figures, and it may be of assistance, subject to my lord, to one of the propositions is proportionality. I don't know what figure is the result of the judge's order. Does anybody know? Can anybody tell me what figure would have to be paid in order to satisfy the judge's order? If we can't do that now, I'd be grateful if it could be done in writing, and so that we can actually know, because proportionality requires us to look at the detriment against the order that was made.
It looks as if we allow Ms. Reid to start her submission, she can either provide that immediately or at least by the end of the shorter term on her cases.
My understanding is that it depends on whether you apply the valuations or whether there is a sale. Sale is the more likely outcome.
I just want a figure. I don't,
1.2 to 1.4 million.
Yeah, sorry?
1.2 to 1.4 million.
1.2
to 1.4 million, as I understand it.
Is what figure? What is that figure?
That is what would be received.
Now, tell me, what if you did add interest to this schedule? What would be the figure?
That figure, I cannot give you that figure.
Well, because
we will do so.
And it would be adding interest at a proper commercial rate, probably compounding it on each annual sum from the time when that detriment was incurred. Going right back to 1982 for the first sum, which is £5,500.
We will give some alternative figures.
If my lord is asking for commercial rate, I would like to have interest at the rate that he could have earned, not some commercial purpose, in addition to my lord's.
Yes, I didn't mean commercial in a purely sort of mercantile commercial sense. I meant at a rate that provides real compensation for the loss of the value of the ownership of the money in the meantime.
Yes.
I mean a rate that he could have actually got.
Yes. We will produce such.
By way of investment.
We will produce such alternatives.
Thank you.
Yes.
Can I just clarify, that 1.4 million you gave to my Lord Stevens, what was that figure? I didn't quite catch what the description, was that what Andrew would get on the implementation of the judge's remedy?
Yes, I said it's between 1.2 and 1.4.
Yes.
And 1.4 would be my understanding of what you get if there was if you worked on the valuations.
So that is Andrew's 50% plus 40% share would amount.
The trouble with that is that that hasn't got factored in the discount for the life interest.
No, I understand.
That may be relatively small.
I didn't catch what.
And there are other.
I didn't catch.
So I've had to use an indicative.
How you
rate.
described it. That's all.
So it's 1.2 to 1.4 discounted by the life interest in the house.
There would still have to be a further reduction to that for the life interest discount. Yes, that's within the context of a property worth some £238,000.
And is that after tax or before tax?
That is for him. That is after the tax has been paid on my calculation.
Thank you. Very well. Well, thank you, Mr. Dumont. Ms. Reid.
I wonder if I can perhaps start, not in the way I intended to. Sorry, I'm mumbling through my mask. I do apologise. To start actually by dealing with the figures, because there was a note submitted by us yesterday that dealt with the valuation, but it also carried on and dealt with the effect of the judge's order. And in particular, it dealt with, and this is at paragraph 7.1.
Is this your note or anything else?
It is the note.
Give me one moment.
The note on valuation, that is.
This is note on valuation respondent.
Yeah.
Yes.
Yes, and that was in response to the request yesterday in respect of the valuation. And 7.1, the respondents to be paid a sum of 40% after tax of the market value of the land and buildings. And there were three qualifications. The first is that they're based on various items of tenure. I don't think that need trouble the court. Secondly, that the farmhouse was to be subject to a life interest in favour of the appellant. So these figures are of themselves not accurate because there hasn't been a valuation undertaken as yet. And then finally, that Granary Cottage is to be valued on the basis of, it says MV1, market value 1, which refers, but in fact it ought to read MR1, and I apologise for that. And the market value which of MV1 gives a figure of 2987846, and that includes a figure for Granary Cottage at 354,588. But on the basis that there's going to be a buyout as opposed to a sale, and we don't accept, as my learned friend puts forward, that there is bound to be a sale in this case. The judge didn't order a sale, and he clearly envisaged that there might be the ability for the remaining parties to buy out. The effect of the judge's order was that if there was going to be a buyout, then the value of Granary Cottage should be reduced to its rental value. In other words, MR1. And the reason for that, as I understand it, and I'm sure I'll be corrected if I'm wrong, was the fact that if there was going to be a buyout, then Granary Cottage would effectively be used for a new agricultural worker.
Whereas there's no need to do that if there's going to be a sale.
Yes.
Yeah.
So the upshot of that, as the notes...
So the £9,600 is the rental value?
It is. It is the rental value. And therefore, the amount that would need to be paid out would be 40% less the value of the life interest. So that would be 1,057,143. But that doesn't, as I understand it, and I'm sure my learned junior will correct me if I'm wrong, that doesn't include the impact of taxation.
No.
There would be capital gains tax.
Just for us, though.
But that capital gains tax, if there was a buyout, would be a potential liability, and I don't want to put it any higher than that at the moment, on Andrew, because he would be disposing of an asset in exchange for money. Nobody else would be disposing of anything. And of course, if there was a buyout, the impact of inheritance tax at the end of the day would be that there would be agricultural property relief available.
So why is Andrew disposing of an interest?
I put it potentially because it's a difficult point and not one, I'm afraid, that overnight we were able to completely get to grips with. It would be because effectively he would have an equity which was being disposed of, or it might well be that the HMRC would regard it as the disposal of a chosen action. So if there was...
Arising from his claim in proprietary estoppel, you mean?
Yes.
So whether an equity... Oh, gosh, how interesting. Yes, I can see the problem.
Well,
I can see why you're cautious.
My Lord, it's not a straightforward tax issue, but if there was... The point is, if there was going to be any tax, it would fall on Andrew.
But that's not... But the judge's order simply leaves Andrew to pay that if it's payable, as I understand it.
Yes.
It doesn't affect the amount he gets paid. It's just whether he has to pay tax on it.
Exactly.
Yeah.
Exactly. If there's a sale, the position is rather different, and of course it depends on what the value of Tump Farm happens to be at the date of sale. Nobody knows that. But the respondent's entitlement of 40% on the current valuation is 1.195138. that doesn't take into account any life interest, so it's going to be lower than that.
But on a sale, Granary Cottage comes back in at
Yes.
some assumed element of the total
Yes,
property.
at 354,588. So if there's the full, and as the note goes on to say, the full entitlement would be 1,305,945.
945, yeah.
Sorry.
That includes half the business.
Yes. That includes, of course, the business. That includes 1/2 share in the business, and I'll come on to that, if I may, in a moment. And the appellant...
Sorry, so is that figure if the farm is not sold, or if it is sold? Because you go on to say if the farm has to be sold...
That would be on the basis that it buyout. It must be a buyout.
Yeah.
Because the value of the half value of the business is 500,000, just under.
Thank you.
So basically for him, depending on whether there's a sale of the farm, it's either 1.3 or 1.4 less the life interest.
Yes.
Which we know won't be as much as the value of the farmhouse of 286,000. So that puts a cap on it, as it were. We can guess the life interest is going to be somewhat less than that.
Yeah.
But it's the life interest of both the appellants.
Yes.
Yeah.
Yes.
Yes. So that is
It'll be valued on the basis of the life expectation of the second to die.
Yes.
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 And the reason that there is no valuation of that, of course, is that the judge, this was something that the judge imposed by way of a scaling down in his judgment. And so the valuers hadn't addressed the point, and it was on the basis that the parties would either agree the figure or alternatively would undertake a further valuation. And of course the way in which this litigation has proceeded by way of appeals has meant that hasn't taken place as yet. But dealing also with, if I may, the 360,000 figure that appears in the particulars of claim, that, of course, was a schedule designed to show part of the detriment that had been relied upon. And it was the difference between the agricultural board wages and what, in fact, Andrew received. It was limited in that, it was very much limited in that way. It didn't represent any sort of comparison with what he might have obtained in the open market. And I would remind your lordships and your ladyships of what was said at paragraph 270 by the judge at page 286 of the bundle, that Andrew was a hard-working, accomplished and forward-thinking farmer. And so that there is that aspect of the matter in our submission to take into account, just for the moment, while not accepting the approach that's adopted by my learned friend to the way in which one should fix a remedy. But if one simply looks at detriment, it's far more complicated than that £360,000, and it's not even that £360,000 plus interest, because there is also what, in fact, Andrew could have earned if he had started out as a young man with those attributes in the open job market. But there are other matters for which that simply wouldn't compensate him. So, for example, he had expected that if he continued to work on the farm, the farm would effectively be his pension in the way that it was a pension for his parents. He would have expected to continue to have an income from the farm. He hasn't got...
All of those are a part of his expectations, though.
They were part of his expectations.
If we're just quantifying what he's lost, then we have to see what he would have been able to build up
Yes.
by way of pension through his alternative
Yes.
life.
Yes, but my Lord, if I may say so, that perhaps illustrates how the fact is not straightforward.
No.
And also, one would have to look as well at what he might have built up in terms of property that he owned. So he never had the opportunity to purchase a property, something that his parents rather threw at him, that he had never left the farm and got a job and bought a property.
But if he went to be a manager somewhere else, would he necessarily be able to be buying a property as opposed to having a house given to him for his use as manager?
Again, it's rather difficult to look at the counterfactual. Potentially, if he was earning enough money, it would have been security for him in his retirement to purchase a property, even if he was provided with rent-free accommodation. But that's not something he can do in his 50s. Learning Friend's right. He has a job now. He has managed to find employment since he left the farm, although it's not been entirely straightforward. And he is provided with accommodation, but he's had no means to build up for himself any capital, and he's now in his 50s.
What is your submission following from that? Is it, well, this is just all too difficult to value reliance and so forth, so one should not approach this on a reliance base, it must be an expectation base? Or is your submission, it's all very difficult, but you accept that the court has to do this kind of difficult quantification in lots of different areas, but it's got to be something added on to the 365,000 plus interest?
Milady, our submission will be that compensating for the detriment, which is the way that Learning Friends put their case, is not the appropriate approach. And it is the justification for it, in particular the justification put forward by Professor McFarlane, is very much on the basis that if one compensates for the detriment, one takes away a necessary ingredient of the proprietary estoppel. And having taken away the detriment, having compensated for it, there's no unconscionability, and that is really the end of the matter. One simply has an unenforceable promise. And for reasons that I will submit, we would say that, first of all, that is not the appropriate approach, because it simply doesn't give any primacy to the promise that has been made. Secondly, it gives rise to considerable difficulties in actually ascertaining how to compensate detriment for something such as has happened in this case, which is 30 years of spending one's career working on a farm. And thirdly, we would say that there is little support in the cases for such an approach. And the way in which that is squared by Professor McFarlane is to say that if the object is to prevent harm occurring to the claimant because of the detriment that they have suffered, that sometimes the only way to deal with that is to vindicate expectation. And that is why so many of the cases focus on expectation. So we would say that there's little support in the case law, both in England and elsewhere, for such an approach. And that is our primary approach to the appeal, because the two major objections that appear to be raised in the appellant's case are, first of all, the fact that the approach of the courts should be based on compensating for detriment. And I'm avoiding the term reliance loss, because that has its own difficulties of working out what's meant. But Professor McFarlane talks about compensating for detriment, and it's my submission that that is the right terminology. That is the first point, and the second point is, of course, the acceleration point, which Maloney Friend hasn't particularly developed it in oral submissions, but goes as far in the case of the written case of the appellants to say that actually the court should do nothing if presented with what might be perceived as a premature claim. So where the promise has been of an inheritance, the court should do nothing until the parties are no longer there, the parties have died.
Well, that's more of a problem, as it seems to me, if you're arguing that the court should fulfil the promise, as to why, how you square that with providing a remedy now which he never would have got had the promise been
Yes.
fulfilled in real life.
Yes, my Lord, that is of course right, that if one is going to take out the element, compensate for the detriment and take out that necessary ingredient of proprietary estoppel, then absolutely inevitably one is going to have to do it now. That is the point. So the 2 points are we would say alternative objections to the way in which the court has approached the matter.
But to establish that there is no venturing beyond the minimum equity, you have to be sure that he's not getting now more than the present value of what he would have got if the expectation had been fulfilled. It's simply a matter of convenience of monetising it at today's date.
Well, Milady, yes, except that perhaps one thing that is very clear here is that what the judge did was not to give effect to the promise. It's what he did do. What Andrew expected was that he would inherit his parents' share of the partnership of the business, and of course the judge does no more than to effectively say he should have what he was already entitled to. There might be some difference in terms of valuation, in that on a dissolution the debts would be taken into account, and this was a valuation report of the value of the business as a going concern. But the judge didn't give him more than his already subsisting 50% entitlement of that particular, of the partnership. So there's already, in a sense, a scaling down there, because what Andrew expected was not just to have the land, but to take over the business.
Yes, but no account has been taken of the liabilities. So how does that square?
Well, there were, I mean, Milady, the reality of it is there were few liabilities in this particular case. So the difference is perhaps more a difference of principle than otherwise.
Yes, but that's what we're concerned with.
Yes.
Well, can you just help me on that second point? But by all means do so at 2 o'clock if you prefer. You say he didn't get anything for his expectation that he would get the business. Mm. The expectation wasn't, in a sense, bearing in mind Ross was there as well, was it that he would get the whole of the value of the business? Would he get the right to run it?
Yes, because the partnerships had been split out in 2012.
Oh yes, Andrew, of course, by then was a 50-50
yes,
in the,
by way of
in the farm next door. So you do say that his expectation in relation to the business was not merely a right to run it, but the whole business.
He would inherit the whole business.
Yes. Yes, I see.
And he would be put in a position where he could buy his siblings out.
But that was more the splitting of the partnerships. Wasn't that more due to his falling out with Ross than with his falling out with the parents? And that's not what we're here to put right. I mean, he's got no claim against Ross for failing to fulfil some promise to him.
My lady, the point I'm making is that he already had 50%. That the effect of those arrangements in 2012 was that he already had 50% of the business. He was already a 50% partner. There has been no formal dissolution of the partnership, and there has been no payment out to him. So what he gets, it may not be quantified and approached in precisely the same way, but what the judge was giving him was no more than he already had.
But the business is tiny in value compared with the land.
Oh, yeah.
It's smaller in value. I accept that, my lord, yes.
And what about the position of the, I'm sorry, maybe better after at 2 o'clock. What is the position about Ross and Jen and their potential to be subject to inheritance tax that is being avoided by your client? Perhaps it's best to deal with that at 2 o'clock.
I'll resume 2 o'clock.